On your in-custody docket, he has 2 cases: an assault, family violence that was a prior bond forfeiture, and a failure to ID. I was appointed this morning on those cases, and we have filed bail orders.
Okay.
On the older, we're requesting PR bonds, sir. On the old assault, family violence, he did let me know, he was in communication with his attorney, and the his appearances were being waived over an ERD court. I do show a reset from July 1st saying he doesn't need to appear, and setting it for July 3rd where he does need to appear, and his signatures are not on it. And he said he did not know. But
He picked up a felony violation of a bond condition.
that's correct, Your Honor. That was filed as a 2B warrant.
I don't know anything about the cases, and I haven't spoken to him in a very long time. Does he speak English?
He does, yes, sir.
Great. I'm going to have them. Is he bringing? They're bringing him up. He has not made bond on the felony case, so.
That's correct.
Good morning, Mr. Mendoza.
One time.
Sir, you're charged with 2 cases with us. You were charged with assault of a family member. You're now also charged with failure to identify oneself to a peace officer while being a fugitive from justice. That allegation kicks it up to a Class A, so you're also facing a year in jail and/or a $4,000 fine. This case the assault is a year old. I have no idea what is going on with it, so I'm going to have you refresh my memory real quick. What happened, please?
On the AFM?
Please. On all 3.
So on the AFM, which is the original charge, on April 6, 2024, officers spoke with the complainant witness who stated she was involved in a physical altercation with the defendant after the defendant became upset with her over food and struck her several times with a closed fist in the nose and mouth, causing her pain and visible injury. Officer observed the complainant witness to have a swollen bottom lip with a small laceration, and she was holding a bloody towel that she used for her nose. Defendant was identified by his Texas driver's license, and the defendant and the complainant witness have been in a dating relationship for 8 years. So that's the oldest AFM. Do you want me to do the felony?
Yeah.
Okay.
What?
It's on the felony. On June 4th, 2024, officer responded to a disturbance call and spoke with the complaining witness. Complaining witness stated the husband threw her on the wall after she called his mom to complain of his behavior. Complaining witness said she had a protective. Shh.
I didn't hear any of that.
Officer, on June 4th, 2024, officer responded to a disturbance call and spoke with the complainant witness. Complainant witness stated that her husband threw her against the wall after she called his mom to complain of his behavior. And then she stated that she had a protective order against the defendant. And then the failed to ID. On April 11th, 2025, officer dispatched to an unknown disturbance call for service. Officers arrived on scene, knocked on the door. Officers observed a male come to the door, but quickly move out of the way, not wanting to answer the door. Officers observed the defendant walking out of the door, stating that he was only having a verbal argument with his wife.
So
Officers-
now a new fight and that's what brings the cops to the house?
I believe so. Officer spoke to the female on scene. Officer stated the female was not answering questions due to not wanting to get the defendant in trouble. Officer observed the name and date of birth the defendant provided to officers for not coming through a TCIC search. Officers advised the defendant that if he does not have proper name and date of birth, he'll be charged with failure to identify. The defendant then confessed and provided his real name and date of birth. The defendant stated he did not want to go to jail for a warrant that he had. And then the officer observed that he had a felony and a misdemeanor warrant.
The reason I'm trying to, you speak English, right?
Yes, sir.
The reason I'm trying to figure what's going on is because she's asking me to give you a PR bond, but we've given you bond after bond after bond. You've been in flight status for about nearly a year. And now when the cops come to try to talk to you, you try to evade again. You know what I mean? Are we just going to need to give you chance after chance? You continue to you just don't give a shice about bond conditions, man. Really? I mean, I get it that he may have not signed it or whatnot, but you can't just be out of sight, out of mind for an entire year and expect good things to happen. So, I mean, really, we've given you PR bond after PR bond. It would just, at some point, I have to say when, so that we mean business. There's no more revolving doors, really.
Your Honor, on the original AFM, it looks like they did do a written call The complainant advised that the reason that she had a bloody nose is because she does drugs and was doing cocaine. He did have the PR bond. The VPO was a 2V warrant, so he wasn't given bond and didn't come on that one.
Yeah, but he had warrants out for both. Apparently knew about them. So I'm
Well,
not.
it didn't say that he knew about the felony warrant,
Well, I don't know,
He had
but
a warrant out.
but you can't make believe that he knew.
I mean, I can, if you want a bond reduction, I'm willing to give you a bond reduction. I'm not gonna give you another PR bond, dude. Really, I'm just, no more PR bonds. And you know, you've got these cases out. Just, you can't out of sight, out of mind. And the only reason you're here now is because you got into another damn argument. So, Mr. Mendoza, I am now issuing another protective order on this case. And I want you to understand that the Texas Constitution does not allow me, but in extremely limited circumstances, to have a hearing to hold someone at zero bond. This is now one of those cases. If you continue to violate protective orders, we can have a hearing to hold you at no bond. Do you understand? I don't want you to have contact with this person. No means no. Doesn't mean, please, baby, get me out of jail. Every phone call is recorded. Take note when you're making phone calls. Every phone call is recorded. Do you understand?
Yes, sir.
I'm not asking for much. All I want are my streets to be safe. And if you can,
Yes, sir.
just don't have any contact, don't have any weapons, and that's it.
Sir.
If you want a bond reduction, I'm happy to give it to you, but I'm not going to just continue to give homeboy PR bond after PR bond after PR bond. Just not, you know.
Would the court be willing to reduce the bonds for $1,000?
I'll cut it in half. So on the assault, 2,500. I'm going to leave the failure to ID as is. But I'm telling you now, I don't know if you're going to get out, but if you do, there is a residential restriction. You cannot go within 200 feet of where she lives or where she works. Do you understand?
Yes, sir.
No alcohol, no illegal drugs. You will be randomly tested. No contact and no weapons. Do you mind? All I need you to do is file the MOA because we'll have him, pre-trial is going to, make sure that you're in compliance. All right, Mr. Mendoza, so what we'll do is the felony case is set for June. So what we'll do is, I don't like to set the people for more than 30 days, so you just don't get forgotten about. We can set you for 30 days, come back, and then, go from there. Okay? All right. Yes, ma'am. Thanks.
This is a textbook judicial warning firm direct and meant to deter judges often use this kind of language to emphasize consequences and public safety.
Are you doing a plea?
No, this is an arraignment, but I also have a plea.
Santimanes?
Is an arraignment.
109 days old.
Yes, apparently, we just got hard on this case. Apparently, he's supposed to come to his first setting, but he tells me he couldn't get a ride, so he didn't come. So here we are. He posted a new bond. So it's as though we're starting over. So I just need to look at the discovery and then we'll go from there, Judge. It's a .07, not .076.
For
Expired.
Santimanes, you are charged with driving while intoxicated. You are facing up to 6 months in jail and or a $2,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you.
Judge, on December 27, 2024, a law enforcement officer was dispatched to Clear Street and Allenville Road to back up an officer on traffic stop. Law enforcement officer had stopped the defendant's motor vehicle for expired registration and loud noise and vibration. The law enforcement officer made contact with the defendant, the driver, and the law enforcement officer observed the defendant spraying cologne over his body several times. He also observed the odor of an alcoholic beverage, red watery eyes, slurred speech, and the defendant stated that he was drinking alcohol at an unspecified time with some friends at a trailer park. The defendant's girlfriend requested they meet, which is why he was driving. The defendant consumed 3 bottles of 12 ounce, Modelo beer, approximately 1 hour prior to the law enforcement officer contact. Standards for sobriety tests were administered, and the officer observed 4 to 6 on the HGN, 4 to 8 on the walking turn, 4 to 4 on one leg stand. And while administering the HGN, the defendant had a distinct side-to-side sway. During
You
the
say side to side sway?
correct, Your Honor.
Okay.
During the walking turn, the defendant used his arms for balance for the entire test and hopped to maintain balance for approximately 10 seconds. The defendant consented to a breath test and the .076 and .073.
Got it. Okay, Mr. Santibanez, I'm going to find that there's sufficient probable cause to go forward with your case. Any prior to DBIs? Does he have a license?
He does not, Your Honor.
No prior to DWIs and his license is still.
Okay, as long as you have a valid Texas driver license and liability insurance in your name, you may continue to drive. I am ordering you not to consume alcohol, illegal drugs, unprescribed controlled medication. I'm going to randomly test you. If I find that you're using alcohol or illegal drugs, it will not go well for you. I will put you in jail. I don't know what your immigration status is, but if you're not in this country with permission and you go to jail and immigration finds you, they can put an immigration detainer on you and you will be stuck like Chuck in there until this case is over with and then you get shipped off to immigration. Do you understand?
Yes.
So your case is now 109 days old. We don't set cases very long after for trial, so get ready. Do you understand? Okay.
Yes.
I'll have you sign a recess with Victoria. After that, we'll have you meet with pre-trial and then you're good to go.
Now we shift into probable cause. This is where the court evaluates whether the facts presented justify continuing with charges and restrictions.
Hey, good morning.
Pretty counsel on your docket again. We worked out a 4-year deferred upstairs, and he's applying for interstate compact. They pushed us to Monday to get the supporting documentation. Judge, I talked to Mr. Jurisic by email yesterday, and he's made a time served offer on the DWI here. I wanted to see if that's something the court's willing to accept, but that time
It's a
served.
first, right?
It is a first.
I'm okay with that.
That offer is dependent on him entering the plea on the deferred. So if we'll push to Monday, he's got a plea on the deferred to get he hasn't pled on the deferred because we pushed to Monday so he can apply for interstate compact. Because he's a California resident.
Come up, Mr. Greathouse.
Is that okay? Okay, just check. Probably around the 180 mark, I think it was.
Of course. I don't have a problem with it. Yeah. You have to be very, very careful. You know, here in our court, we do the fugitive cases. So I handle all the cases here where someone gets arrested in Harris County for an open warrant they may have in any other state, Wyoming, Delaware, California, Oklahoma. If you have a warrant that originates in another state and you're arrested here in Harris County, I handle all those cases. One of the cases that is most difficult and frustrating to deal with are the interstate compact cases. And she's shaking her head over there because it really is. She's our fugitive prosecutor. Because if you do something to violate conditions where they have to issue an interstate compact warrant and you end up in jail, you will sit there for months on end waiting for anything to resolve, waiting for the interstate compact people to do whatever they need to do to resolve cases. So if you are getting on this deferred upstairs, which is a very serious deferred, right? And you violate conditions and they have to issue a warrant, you could be months upon months sitting in jail. So the only thing I'm trying to tell you is take it seriously. Don't take it as a joke. Everything is done on timing, so you got to do stuff on time. Don't take off. It's the worst thing that you could possibly do when you're on a deferred. Just do what you're supposed to do, and everything ends up well. When you don't, on these interstate compact cases, it's a complete nightmare. You want Monday?
Yeah, please.
Absolutely. Okay, so we'll push you off Monday and then we'll see you then. Okay.
Possession of a victim's key fob is a powerful piece of evidence that directly links a defendant to the alleged crime scene and strengthens the case significantly.
This is on Helsinki. Al-Salkini.
Yes, Your Honor. That's the only issue we may run into. Your Honor, we have reached a resolution in this matter. The state has made another offer, which my client is interested in. However, I'm taking into consideration the language barrier here. I'm not sure, but I have to
But I have
double
a
check.
translator.
No, I'm saying, he understands that an offer is a BIP class. The thing is, I'm trying to see if the BIP class is offered in Arabic. That may be the only thing.
It's an online?
Yes, I'm quite sure they can.
Hold on.
Yeah.
It's an online bid class?
Yes, sir. I haven't seen one, so I didn't want that to be an
I
issue
say
when it comes to
something?
timeliness.
I usually have experience on these courses. Usually they provide an interpreter,
Okay. They'll
even
provide.
for the, yeah, even for the classes.
Okay. Is that something we have to request prior to?
Yes. Yeah.
Okay. Okay.
Yes. For each class.
Okay.
I'm sorry to just interrupt. I was
That's
just
okay.
sharing my
That's all right.
experience.
Okay. Because most of them I've seen are English or Spanish, but I didn't know if that would be,
Arabic and French too.
okay.
So how are we gonna get that done? I mean, his case is 227 days old. I'm gonna give you guys a couple weeks to get it done.
Yes, we can figure it out. I'll figure it out.
And then I'm gonna tell him I'm setting his case for trial.
I'll figure it out.
So-
If she gave a possible alternative as far as getting an interpreter in to assist with the course, so I can.
Mr. Al-Salkini, come up.
I didn't know that was out there, an option.
Okay, guys, I'm gonna have a translator interpret, so please keep quiet. Okay, Ms. Kuja, thank you for coming. Will you raise your right hand? Do you solemnly swear to interpret word for word what transpires here?
I swear.
Okay, thank you. Mr. Al-Salkini, you are charged with assault of a family member.
مرحبا أستاذ السكين. أنت هنا اليوم بتهمة الاعتداء على أحد أفراد الأسرة.
Your case is old at 227 days.
ملفك قديم هو 267 يوم.
It appears that you have worked out a plea bargain agreement that you wish to accept.
حضرتك اتفقت على يعني إدانة اللي يعني ناقشت إدانة واتفقت عليها، حابب تتفق على هذه الإدانة. Yes.
Due to the age of the case, I'm giving you 2 weeks to complete this class.
بما إنه الملف قديم راح أعطي حضرتك أسبوعين من شان تخلص الحصص.
If it is not complete, your case will be set for trial.
إذا ما تم انتهاء أو استكفاء الحصص بأسبوعين فراح أرسل ملفك للمحاكمة.
Okay, so we'll give you whatever day you want, and then we'll see you in 2 weeks.
Yes, sir.
Okay.
Thank you.
All right. Good luck, sir.
Thank you, Phil.
Thanks.
At this point, the allegations become far more serious as triggers immediate protected concerns and heightened judicial scrutiny.
Let's dance.
We are approaching on Mr. Cassius Bond. He's in custody, fugitive case.
Bond?
Bond.
Bond wants a bond?
No, he does not. He signed a waiver. We're approaching to see if you want to admonish him, which I think he would need.
So what's the problem? What happened? Because I can't look at anything. Nothing's working.
Judge, he has cases from Tennessee. I'm not sure that's what you're asking, but he hadn't signed a waiver yet. We just got that
Okay,
signed.
so yeah, do you mind bringing up Mr. Bond? All right, so theft of property, identity theft times 10.
Yes.
Fraudulent use of a debit card, 60,000 to 250,000. Wow. And he's on deferred for burglary of a habitation.
That I believe he just took. Yeah, he just,
Yeah,
and he wasn't aware that he had a hold whenever he took that offer.
Good morning, Mr. Bond. Shh. So the reason I'm bringing you out now is you need to make a decision on what you would like to do. You are wanted out of the state of Tennessee, specifically the county of Rutherford, for theft of property, 60,000 to 250,000, identity theft times 10, fraudulent use of a debit card from 60,000 to 250,000. You're wanted for those whole host of charges. There are two things that you can do. Well, specifically three things. So they want you. You can either waive extradition. If you waive extradition, we give Tennessee 14 days to come get you. If they don't come get you within the 14 days, Harris County releases you. If that happens, that warrant will always remain in effect. And it will always remain in effect until you go back to Tennessee and take care of it. The problem is if you don't, at some point, it's going to hose you because you just entered into a deferred upstairs on a bird hab. So if you are in the middle of your deferred upstairs and then all of a sudden you get taken there and you spend 2 years there, you're going to get hosed on this probation here. So the idea is that you try to take care of everything now while you're still have the understanding of upstairs. Do you understand?
Yes, sir.
The other thing that you can do is you're going to request a bond, but I don't know if I'm going to give you a bond. You know, the other thing is you can fight extradition by saying, hey, it's not me. They got the wrong person. So what I can do is I can, put you back now, have you talk to the lawyer that we've appointed you to see what you want to do. Okay? Do you have any questions?
Yes, sir.
Okay. I guess let me know what you want to do and we'll go from there. Yeah. Okay. Thanks.
Protective orders aren't optional in cases like this. They're designed to immediately limit contact and prevent further harm before the case is even resolved.
Morning, Judge.
Hi.
I'm here on an off-docket matter. It's a request to amend bond conditions that is unopposed by the DA's office. My client, I guess we'll give the case number.
What's the cost number?
It's 2553235.
Is this on Miss Iwoma?
Yes, it is, Your Honor.
Okay.
Situation is that her husband has been given a promotion, and in late May, I think May the 27th, 26th, is being transferred to Blythewood, South Carolina, which is near Columbia, South Carolina.
Okay.
And she would request that she be allowed to go to South Carolina with her husband and appear either virtually at court appearances or be allowed to fly back to Houston for court appearances.
I don't think that there are any travel restrictions now, but it's a DWI second. So she must still comply with the conditions that she has as far as whether she has an interlock, whether she has a scram, whatever the conditions are. I'm okay with her going. I don't care where she goes, as long as she's in compliance with the bond conditions and she doesn't pick up any new cases. That's my only concern.
That's fine.
Did you get the cause number, Anthony?
Do we want to make adjustments to the random drug test?
No, I don't want to do anything special. I mean, she's got to remain in compliance. So the problem is that she may get called upon to do drug or alcohol or drug testing. If she does, she's going to have to go to a Quest diagnostic wherever she is. She could get that done there. I will not accept Punka City, a better drug test, because I want a reputable lab that's ASCLD certified, and I know that's not something where you can just buy a result, and I think that Quest is, pretty reputable. So if she gets called upon to do a drug test, she needs to go to a Quest, and it's on her to get it to you guys, to get it to us, so we know. She's still going to have to come down. Does she have an interlock or does she have a scram? Well, she's still going to have to come down to get it calibrated.
Okay.
So that's on her to come down to get it calibrated. And I don't know how often. She probably does that like once a month, I would imagine. So she's still going to have to get that done. That's not something that you can do remotely. So as long as she's in compliance, I'm okay where she goes there.
Extend the calibration period to make it every 2 months or
Could you extend the calibration to every 60 days rather than every 30?
Because then I don't know if she's like out there and it'll take a while for me to, because I mean, theoretically, I'll extend it to 60 days. It's going to get her time to get over here. It takes me at least a couple weeks to get it. So if she drinks on that day, I'll get the violation in 90 days. And then it just,
Sure.
yeah. So the thing is I can't show you guys favorable treatment that I wouldn't show to anybody else. You know, I want to be fair to every single person. Everybody gets treated the right way. They're the same way. So I'm not saying no, but you just have to comply with the conditions.
Okay.
It may be more arduous because you're going there, but hey, that's the cost of doing business.
It shouldn't be.
Can she, when her court's appearance is set, she needs to, I'm sorry?
Your appearance is waived.
Oh, okay, perfect.
We waive everybody's appearance. As long as you're in compliance, we may never even see you. Well, this is a second, so it's definitely, you know, at some point, we're going to see her.
All right,
Calibration done.
All right, well, that's all we have, Judge. Thank you for your time.
Sure.
Thank you very much.
Failure to identify can quickly escalate a situation. What seems like a minor issue can compound into additional charges, especially when warrants or evasive behavior are involved.